The most important factor is having a judge who will uphold the Constitution and apply the law, not rewrite the law. If you want to write the law, you run for the legislature. We may not like what the legislature does, but our job especially as appellate court judges, is to apply that law faithfully. So I think that's the most important thing.
I believe there are three factors that should be looked at, and I think judicial experience is extraordinarily important when you're talking about an appellate court, because the appellate court reviews the lower courts, and not only does it review the lower courts, but what is done in an appellate court goes into those law books that people see on TV or in places, and those become the law of the land. Those are the cases that other attorneys or judges refer to make their future decisions, not only in one district, but in the entire state. So I think judicial experience is extraordinarily important to understand how the judicial system works, to understand how the process works, to understand that if there was an error in a lower court, to know how to correct that error, and also to know when there was no error, and just to say that there was no error in the lower court. So judicial experience is the first thing. The second factor that I believe should be looked at is a person's qualifications. And qualifications run such a wide spectrum. I think that there's a good measure for that. There were 40 people that applied to be a Court of Appeals judge. I was among those 40 people. And when you apply to be an appellate court judge, they set up an appellate judicial selection committee. This is a nonpartisan committee that is made up half Republican, half Democrat. It's made up of appellate judges, it's made up of attorneys, it's made up of members of the public. And so it's really a cross-section of the state as well as a cross-section of the legal community. These are people who have an understanding of what is required. Be a judge who understand qualifications, and in preparation for that committee, we're required then to submit an application. The application starts at the beginning of your life and ends pretty much where you are at that point, and you have to disclose everything about yourself, whether it's personal or professional. They look at your personal background, they inquire what lawsuits you've been in, if any, they inquire what referrals to judicial standards you've had, if any, and you sign a document that allows them to actually check with judicial standards to make sure you're being straight with them. And also, if you're an attorney, they require that you disclose whether you'd had any complaints as an attorney, not just as those of us that were judges before, but also as attorneys. So it's really important in that they do not only a superficial background check, but they do pretty much of an in-depth background check. This is before you appear before them. You then appear before them much in the same manner that we are here today, only there's a lot more of them. And they get to ask whatever question they want to ask about anything pretty much they want about your background. Then they, out of those 40, they selected a number of us that, I don't remember, it seems like 5, but they select a number of us that they consider qualified based upon the answers we give, based upon our backgrounds, and those are then sent for determination as to who's going to be the one that gets appointed. I had the honor of being appointed to the Court of Appeals. And so I think the second part is the qualification part. And I think that's a good measure, because that's a measure that is done by people who understand what it takes to be a judge, and it also involves a complete disclosure. The third part, I think, is ethics. It's important that we have judges in this state and on this court and on every court who are ethical, who have integrity. And so when we look at these things, and when the public is looking for whom to vote, that's another important factor. I was privileged to serve on the Supreme Court Code of Judicial Conduct Committee as chair. I did that for a number of years. I was also a member prior to being chair. So I'm very familiar with the Code of Judicial Conduct. I require strict adherence for myself. I think that we as the judges who are in the appellate courts should require all judges to adhere to those high ethical standards. That would be the three things that I think are the three things that should be looked at. Well, you know, there is a certain amount of discretion that comes into play in some of these cases. We certainly have to follow the law. I believe in following the rule of law. I am bound by Supreme Court precedent. When the Supreme Court says that a certain interpretation is the interpretation, then I'm bound to follow the Supreme Court's ruling. However, as I go around the state, I tell people that I may not be able to express my opinion on some of the issues that they want to know about, but I'm very interested in hearing their opinion. And the reason for that is because as we rule on cases like this, and DWI cases really touch the very essence, I think, of every New Mexican. As we rule on cases like this, it's important to know where the public sentiment is. I actually, in my last year and a half, made, I believe, an important ruling on DWI cases myself, which was a case where a passenger was being charged with DWI, and the question was, can a passenger be guilty of DWI? This particular passenger was someone who had been drinking with the driver in various bars, and as I recall, had been kicked out of various bars. He understood the driver had been drinking. After that, because the driver was incapacitated, he went and bought alcohol and took it to the driver. They continued to drink. He encouraged the driver to drive, and they ended up involved in a vehicle homicide. And the question before me at that point was, can a passenger be guilty as an accessory? And I found that a passenger can. Under those kinds of egregious circumstances, yes, a passenger can. An unknowing passenger who's just there is a different matter. This is one where there was what I would call, and what I have described as, egregious conduct. So yes, I think it's important to take public views into consideration and keep them in mind.
Well, you certainly consider it, but that's really a question for the legislature. As a judge, your obligation is to apply the law, and so the hardest time to apply the law is when it leads to a result that you don't like, but you have to do that, and then the people know where they need to go in order to change things. You know, we talk about not wanting our courts to be political. One of the questions I often get is about, you know, it's a little awkward for judges to campaign for a position. But what really makes the courts political is when they step into the breach, so to speak, and write the law that they want, as opposed to what the law is. I've heard of those cases. I'm not familiar with the details of those cases, but and I'm not, you know, permitted to pledge that I would rule a certain way, and I don't think any judge should do that, because you don't know what the facts of law will be when they come before you. But the obligation, especially of the appeals court, as I say, is to start with what's written on the page, and sort of go from there. We start with what's written on the page. I try to stick to the language of the statute. I was a workers' compensation judge for about 3 years, and it took me about 2 days to realize that my job was actually a lot easier if I just follow the law that's there. The people that come before you on both sides, whether it's a business owner who's struggling to make it work or a worker who's trying to pay the bills, both have compelling situations, if you will. But my job as a judge was to not see how I could make the court work for either side, but just follow the law to its conclusion. And sometimes it would be for the one party, and sometimes it would be for the other. That's my approach, you know, we have a phrase in some of our cases, it's called the beguiling simplicity of the plain language. And I always find that to be strange because, you know, if it's simple, then we should keep it simple, and if it's not, if it leads to an absurd outcome, then the legislature should come in and change it and fix it. And the quickest way to get them to do that is to actually apply it as it's written.
You know, my judicial philosophy is not complicated, and my judicial philosophy is that I follow the law and I apply the law fairly and equally to everyone that comes before me. I take every case seriously. I did this when I was on the district court for 17 and a half years, and I do it now. When I read a case, it may not seem to me that it involves maybe as much money or as heavy an issue as maybe another case, but I know for the individuals involved in that case, that's the most important thing in their lives, and so I treat it like it's the most important thing in a human being's life, and I believe people should be treated not only in a fair manner, but with dignity. There's no reason why you should belittle people or treat them inappropriately, particularly on an appellate court. You know, on the appellate court, we sit in groups of 3. This isn't like a district court where, as a district judge, I was able to make my own decisions. On the appellate court, you have to find at least one other person to agree with you, so that you can form a majority for the opinion. And so in these kinds of situations, it's important that you make sure that your demeanor is appropriate and that really what you're doing is arguing the merits based on the law and applying it fairly to the facts.